Good afternoon, ladies and gentlemen. My name is Matt Dumont. I am the managing editor of the Journal of Healthcare Law and Policy, and it is now my distinct honor and privilege to introduce the next moderator for Panel 2. Our moderator for Panel 2 is none other than Hope Randolph. Hope is the symposium chair for the Journal of Healthcare Law and Policy and brought together this entire event through her tireless efforts, blood, sweat, and tears. She is just the best person to have spearheaded this. It was my honor to work beside and at her supervision. Hope is a third-year law student at the University of Maryland Francis King Carey School of Law, and she has a Bachelor of Science in Kinesiology from the University of Maryland College Park. It is now my distinct honor and privilege to welcome Hope to the stage.
Thank you, Matt, for that excellent introduction. Good afternoon, everyone. My name is Hope. Again, I'm the chair of this year's symposium. I would personally like to thank everyone for being here today. It truly means a lot to us in the Journal. I have the pleasure of moderating our second panel in the community. But I first want to provide a little bit of background about my personal experience with this particular topic and law school. So I come from a public health background as a student in a kinesiology major at the University of Maryland. And there we talked a lot about mental health and really a lot of the problems facing many people struggling with mental health in our country. But when I came to law school, unfortunately, I didn't have much exposure to these topics anymore. I was exposed to the criminal system, the civil system, but in those conversations, we really didn't discuss mental health issues. In my last semester, currently, I'm taking the public health clinic with Kathy Hoke, who is amazing, but that's really been my first real exposure to discussing mental health issues. And that's why I think this is such an important conversation today, because someone like me with a lot of background in mental health has only been exposed to it really once in my academic career, but I can only imagine the people who will never have that conversation leaving law school. So again, I think this conversation today is very important. So this panel will analyze the multiple tensions that arise within legal institutions and other social service agencies in balancing empathy and individual needs with concerns that arise from the community, recognizing the dichotomy of community stakeholders such as local government, law enforcement, and healthcare providers. So now I would like to introduce our distinguished panelists. Dr. Shelley Weikel is an associate dean and chair at the University of Maryland Baltimore County School of Social Work. She conducts community-based research on the intersection between trauma and substance use in diverse groups. She is a member of the editorial board for the Journal of Loss and Trauma and is also a member of the review boards for the Journal of Substance Use and Misuse and the Journal of Social Work Practice in the Addictions. She currently serves as a commissioner on the Commission on Accreditation for the Council on Social Work Education. She is a past president of the LGBTQ FSA and current co-chair of the All Gender Restroom Steering Committee at UMBC. She also serves as a member of the Inclusion Council at UMBC, where she is a co-chair of the Land Acknowledgement Work Group. She has worked extensively as a clinician in both substance use and mental health treatment settings and has taught numerous continuing education workshops to practitioners. She has multiple peer-reviewed publications and book chapters, as well as national and international presentations on her research and practice interests. Ms. Ruth Schethner is a doctoral candidate in socio-medical sciences at Columbia University's Mailman School of Public Health on the sociology track. She's also a predoctoral fellow in a NIDA-funded T32 on HIV, substance use in the criminal justice system. Her work uses mixed methods to study the public health harms of criminalization along the criminal legal system continuum, with specific interest in policing criminal laws as structural determinants of health, collateral consequences of sex offender registration and notification policies, and harm reduction in criminal legal settings. Prior to coming to Columbia, Ruth was the director of the Goldring Reentry Initiative, a program housed at the University of Pennsylvania's School of Social Policy and Practice that supports individuals pre- and post-release from Philadelphia's county jail system. She completed a Master of Social Work and Master of Public Health at the University of Pennsylvania and a Bachelor of Arts in Public Health at Brown University. Louis Bossing is a senior staff attorney at the Bazelon Center for Mental Health Law. He works on a broad array of issues affecting adults and children with mental disabilities, including community integration, education, and decriminalization. Before joining the Bazelon Center in October 2007, Bossing worked as a staff attorney in the Civil Rights Division at the United States Department of Justice and at the Legal Aid Society Employment Law Center in San Francisco, where he represented clients in Americans with Disabilities Act litigation in employment and educational settings. A former modern dancer, Bossing holds a BS in Performance Studies from Northwestern University and his JD from the New York University School of Law. Please welcome our panelists. I will now turn it over to our first panelist, Dr. Weichelt.
Thank you. Thank you very much. So if I start to yell in this mic, somebody, I'm not used to speaking in mics, and sometimes I start to project. So if I do that, do you let me know. But I am really excited to be here in this beautiful space. And I was mentioning to folks, this is, I think, the first time in 3 years that I've spoken publicly outside of classroom speaking, thanks to COVID. So it's really, really great to be here live and in person and in dialogue and discussion with others. So what I'm here to talk to you about is trauma. And we've already alluded to trauma in the earlier panels. We talk about trauma a lot nowadays. We see it on TV a lot. We see it in social media a lot. We hear people talking about it a lot. We say it a lot. Everybody thinks there's an expert in it, and it's there, right? But I've been around long enough to remember when it wasn't there. So there's a risk in minimizing how much trauma is involved and how much impacts people when we're dealing with social services or legal systems or healthcare systems. When we're dealing with human beings, we're probably in some way going to be dealing with trauma. And there was a time back in the day when we were reading The Courage to Heal and sitting around in living rooms crying with each other about how we were going to help people with trauma and get people heard. So there was, it was delegitimized. And even when you go all the way back to Freud and the etiology of hysteria and him withdrawing his paper and making the update that it wasn't that the men were sexually abusing their daughters, it was that they were fantasizing about being sexually abused. And the World War I shock syndrome was really, some people were lacking in moral fortitude in some way, unless it was really near a bomb. Otherwise, they were just slackers. So people's experience of trauma historically has been delegitimized and not paid attention to. And so people worked very hard, probably starting with the Vietnam War folks and rape trauma survivors in those days, to understand the syndrome and symptoms associated with experienced traumatic events. And that sort of launched us into discovering what is trauma? What does it mean in people's lives? What are interventions that we can do to address trauma? And what are interventions that work? And since that time, we've come a long way. We're talking about it a lot. And sometimes we even say we're talking about it too much. But it's an important concept to understand, particularly when we're thinking about social service agencies or court-based programs or health programs. So just to say, what is trauma? Essentially, if a person's coping mechanisms are overwhelmed by a stressful event, it can be experienced as trauma. And that's sort of the simplistic way of saying it. But we do have our DSM-5 TR nowadays that in the U.S. we sort of use as our diagnostic Bible. And PTSD criterion A, exposure to actual or threatened death, serious injury, or sexual violation, either directly experiencing or witnessing or learning about a friend or loved one who's experienced such an event. And the kinds of events a person might experience could be combat, which we've mentioned, childhood sexual abuse, adult sexual abuse, sexual assaults, robberies, auto accidents, events, severe events like that. And the notion that a person experiences an event means that they are now traumatized is not really accurate. A lot of people think it is. But individuals respond to potentially traumatic events in different ways. Some people develop PTSD. Some people might get depressed. Some people have very little, if any, reaction and are indeed resilient. So an event in and of itself does not make it mean that a person has PTSD. But in order to be diagnosed with PTSD, one has to have the qualifying event. And when we think of the effect of trauma from the PTSD perspective, it's flashbacks, intrusive memories, avoidance of thoughts or situations that might evoke such memories, negative thoughts and hyperarousal. People kind of get the alarm bell comes on. So if you hear a loud noise out there right now, you're going to startle. So your alarm bell goes off, and you go, oh, it's just a guy with a lunch stuff, he dropped it. The alarm bell goes off. Sometimes people who have experienced a traumatic event, that alarm bell comes on, and it's sort of stuck in that hyper-aroused state. So that's what we think of when we think of PTSD. And as I said, not everybody that experiences a traumatic event develops PTSD. Now, let me hasten to add that PTSD is not the only thing that people experience in relation to having experienced a traumatic event. Sometimes people experience other kinds of issues that you don't really see in DSM-5, and in fact, people have been fighting to get them in DSM-5 for like 20 or 30 years. Like Bessel van der Kolk's been trying to get developmental trauma syndrome in, and Judith Herman talked about complex trauma and complex PTSD probably 30 or 40 years ago now, in which if people experience interpersonal traumatic events over a prolonged period of time, they're more likely to experience complex trauma reactions. It's different if you're being sexually abused every night from the age of 8 to 10 than if you experience a single incident sexual assault or a single incident robbery. Those are obviously bad things to have, and you don't want to have them happen. But that prolonged over time kind of experience of trauma and lack of safety, especially by someone who's supposed to be a trusted other, can create deeper kinds of wounds, if you will. So when we think about a person's experience with trauma and their reactions to trauma, it varies. But a person can feel challenges in interpersonal relationships, challenges managing their affect and emotions, challenges maybe communicating. Substance use is highly associated with trauma and trauma-related problems. So you get the co-occurring kinds of issues, and it creates sort of a complex picture. And one of the things that can happen in a traumatic event is the experience of shame. And the experience of shame is a very painful emotion, and it's fundamentally about the exposure of a flawed self. And the exposure of a flawed self feels really bad, right? So, but there, we use shame in our society. There's sort of like healthy shame. So if any of you have little kids, if your little kids are acting up or fighting, you intervene, and it's momentarily they feel a little shame, and that's what gets them to recoil from that behavior and can be corrective. But a parent sort of reconnects with the child in a connective bridge, and the shame is used as a kind of a healthy socialization process. as opposed to shaming someone in such a way that you're harming them. But shame that gets triggered chronically and inappropriately can become internalized. And in that way, a person starts to operate from a frame of shame. So they're walking through the world feeling like a flawed being that's exposed. So that is a very hard place to be. So our awareness about trauma and the importance about trauma and being able to assess trauma and recognize its many faces is important if we're going to do our interventions. And so we've been fighting for probably at least 30 years now to have trauma-informed care. And we had trauma-informed prisons mentioned earlier, and was that really real? But we've been fighting for trauma-informed care in social service settings and healthcare settings and so forth. We say that trauma is so commonly associated with social and mental health and substance use problems that we really should have kind of a universal precaution around trauma issues, and that we should assess for trauma, provide support around trauma, and to have a trauma-informed system, though, is not trauma treatment. A trauma-informed system is different than providing direct trauma treatment, right? So a person who provides direct trauma treatment really needs to be a pretty good specialist, pretty well trained clinically, and have a deep understanding of the connections between the kinds of events a person can experience, how they might feel, what other challenges they might have. That's a specialized training. Trauma-informed means that you are designing a delivery service system that doesn't re-traumatize people, that supports people, and at minimum doesn't re-traumatize them. So here's what it should be. Infused with knowledge about violence and victimization, minimize the possibility of re-victimization, be hospitable and engaging, facilitate recovery. Okay, here we go. Operate on an empowerment model, respect choice and control over one's own recovery, minimize power imbalance, relational collaboration, emphasize strengths. So this is why earlier when we were asked if a prison could be trauma-informed, well, we all said no, because obviously they don't do that, right? But in a trauma-informed system, that's the kind of approach that we want to take. And the real keys are safety, trustworthiness, choice, collaboration, and empowerment. So Corey and I is a popular collaborator here today. Corey and I did some work here in Baltimore with Yana. And Yana was a drop-in center for women engaged in prostitution, and that's the language they used at that time. It's criminalized sex work, street-level sex work. It was a drop-in center, and people would go there, and there was no notion or expectation that when you came there you were trying to exit prostitution or that you were required to do anything. You were just welcome to come in and have a lunch or get a resource or hear a talk, and it was really designed to welcome and support folks who were engaged in street-level sex work in the Baltimore area. And we did a project there, and we were doing that project because we were involved with a task force that was trying to think about dealing with a rotating through jail kind of thing. There was a challenge in Baltimore at the time. The neighborhood people were complaining about the prostitution in their streets, and we don't want this in our neighborhood, and there's condoms everywhere, and there's problems, and we don't want these problems, but yet we don't want to hurt the women. And then there were community leaders, so everybody was trying to think of a way to try to address sort of the issues that the neighborhoods were experiencing, and even the women. And they were talking about women. I acknowledge that there can be men engaged in prostitution as well. But there was a lot of talk about what do you do in the court program? And Corey and I said, well, what do the people say they want? What do they want? So we designed a study to go to Yana to learn about what people wanted. And people did think it would be helpful to have a program affiliated with a court that would give them an alternative to jail. They thought it might be helpful. They also talked about how they might have been treated unfairly by police, by social service people, hospital people. One person even said to us, "Sometimes I feel like people treat me like they have rubber gloves on." So they wanted the courts to understand their experience and yet provide help. So that the Baltimore specialized diversion program actually did not require that a person be charged. It was deferred. So if you participated in the program, you didn't have to face a charge. So you participated in the program, and it was working collaboratively with a social worker to try to help get resources that you need, but it was still affiliated with the court. So you still had to sign a thing that said that you'll cooperate and you'll take the treatment and you'll go to the treatment, and you agree to your confidentiality. Not, the person could talk about your case, could check about how you were doing. So you still had that sort of not having complete freedom of choice. There was still a bit of a stick, right? We also worked with a court, did some observations at a court that was mentioned earlier in Philadelphia, the Project Dawn Court, which was more the problem-solving court, where if you didn't complete the program, you didn't come back and face the original charge, you could get sentenced. So it was a bigger stick. So when you have these kinds of court-based programs, these folks and others are rooted in the notion that the reason these folks are here is because they have trauma and they have substance use issues, and that's what's going on here. So we as a court need to intervene in their trauma and substance use issues and compel them to get better, and then they won't do this anymore and they'll participate in society, and we're really helping them, and we can feel really good about helping them. Right? So this notion that people did have trauma experience was well-founded. The literature shows 29% female sex workers had PTSD, the criteria for PTSD. In the general population, it's 9.7%. Our own participants told us, for example, one, I've been raped, I've been robbed, I've been chased with guns, I've been stabbed, I've been shot with a BB gun, I've been tied to a tree on Route 40 and left for dead. It's getting really hot under this light, sorry. And then our participants at Yana told us that they experienced 5 to 14 potentially traumatic events with an average of 10. There were, most had experienced sexual and physical violence across the lifespan, and there was a high rate of PTSD symptoms and other trauma-related symptoms. And the Project Dawn study participants told us that they didn't have quite as much as the Baltimore, but they had an average of 7 life events that were potentially traumatic, and they experienced a bit more modest levels of PTSD symptoms, but still had PTSD and trauma-related symptoms. So clearly, the court thought trauma was an issue, and the participants acknowledged that trauma was an issue for them, but they also said that they thought housing instability, poverty, employment, job training, social connection were also very important issues to them. So the well-meaning court meant to intervene and provide support and keep people out of jail, but what they did was mandate them to trauma treatment. So think about that. And remember those keys: choice, collaboration, safety, empowerment, trustworthy. So here I am, sitting up on my big bench in a big black robe, in a room with a door with a holding cell out there, and a bailiff or a sheriff hanging around there, right? And I say, you must go to trauma treatment. You are required to get treatment for trauma. You are also required to get treatment for substance use. How trauma-informed is that? It is not. It is not. I mean, the court by design cannot really be trauma-informed, even when it tries to be. Like the SPD in Baltimore was trying harder. I mean, they were both trying to be trauma-informed, but there was a little bit less of a stick, right? Even so, when you have that element of coercion, just by being connected with a court, it takes away a lot of the collaboration, choice, safety kinds of key components of trauma-informed care and providing people support around trauma. So people may need help with trauma issues, and it would be important to provide people services, but maybe it would be better if services were provided somewhere other than in a court. So if we provide people access to job training, housing, ways of reconnecting with their families and loved ones, ways of coping, dealing with trauma issues in sort of a deeper way as the person chooses, rather than as I impose. And also thinking about if I am working in a court, do I really have the training to determine what is needed? So if you do a trauma assessment and you identify substance use as a problem, that research indicates that integrated trauma and substance use treatment is, in most cases, the most effective treatment. Do I have that available here? Am I referring people to integrated treatment? Often it was referral to segregated treatment. And it wasn't just referral, it was mandate. And if you don't complete the treatment or do what they say in treatment, then you may have a consequence. So that flies in the face of what trauma survivors need in order to do their work. Their doing their work is their choice about doing their work, not about being mandated by a court to do their work. So the court, we thought, was well-meaning in its intention that it wanted to support and help people, but it cannot be trauma-informed because it determines what is acceptable behavior, what services are needed, what level of compliance with the court and treatment providers is expected, and what reward or consequence occurs when the woman is viewed as not compliant. So it's in its operation, even though their words are saying we want to support people and we want to be trauma-informed and we know trauma is an issue and we're supporting people, which we've fought so hard to get people to do, they're doing it in a way that could potentially be harmful to people. So how do we provide structures and opportunities for people who might end up in the legal justice system, who might end up before a judge? How can we, for specifically these examples, women engaged in criminalized sex work, how do we give them opportunity and option that help them live the life they want? So, for example, one of the women who participated in our study was involved in Project Dawn Court, sort of rotated, went in, relapsed, went out, went back to jail, went back in, relapsed, went out, came back in. But over time, ultimately, did graduate from the program and felt very positive about the program and thought that tough love helped. But that person ended up in very nasty kind of jobs, like cleaning bathrooms and working in the service industry in ways that aren't fun, like emptying people's trash and scrubbing people's toilets and trying to go to school but not being able to afford school and not getting housing support and not getting job training. And so as you can see, that becomes kind of overwhelming to deal with. So the court really didn't provide the resource for housing, safe housing, and job training and supporting the person in meeting their life goals. And so that became challenging for the person. So, our conclusion is, okay, the court means well, and it may be better than nothing at this time, but we need to do better. We do need to attend to trauma, but we don't need to order people to treatment with a stick over their head threatening to go into jail. What we need to do is really hear people's experience and work with them collaboratively to help them get the whole range of services that they may need. So, It's important if you're working in a court system, and if you work with people who are trauma survivors anyway, to be mindful of your boundaries, to do a good assessment, to validate choice, create safety, create trust, and work with people to define what they want in their lives and support people in getting that. Hopefully that was 15 minutes.
Hi there. Again, my name is Ruth, and thank you so much for having me. It's great to be here, and I've loved hearing everything so far. I'm here today to discuss a study that I've been working on that explores the challenges associated with mandatory sex offender therapy, or MSOT, which is one specific instantiation of mandated treatment that we see in the court system. I think and hope that MSOT is an interesting lens through which we can view the complexities and challenges of court-mandated treatment, not only because people who are convicted of sex offenses are a particularly controversial and challenging subpopulation, but because the treatment is often actually statutorily required and not just a function of sentencing by judges or probation officers, so it takes things another step farther. By way of introduction, as it was said, I'm a doctoral student now, but I'm also a social worker, and in my prior life, I was the director of the Goldring Reentry Initiative, a program that worked housed in the University of Pennsylvania School of Social Work that provided therapeutic case management to people pre- and post-release from Philadelphia's jail system. We were one of only a few programs in the city that would accept clients with sex offenses, so we ended up working very frequently with people on the registry, as well as the systems of care and control that surrounded them, which was primarily comprised of MSOT and probation. To begin with, to have a conversation about mandatory sex offender treatment and people convicted of sex offenses at all, I think it's important to have a bit of context for how we got here and what here is. Anxiety about sex and sexuality has long been exploited for tools for social mobilization and dictating terms of social and cultural debates. The methods by which sexuality has been mobilized in service of social and political goals range from subtle and tacit to explicit and violent. On the latter end of that spectrum are modern sex offender management policies, which is an expansive set of legislation that subjects people convicted of sex offenses, convicted of sex crimes and labeled sex offenders to a vast array of restrictions and surveillance. The introduction and proliferation of our modern sex offender management policies coincide with the rise of mass incarceration in the late 20th century. During this period, as we all know, incarceration rates soared while crime rates remained relatively unchanged or declined. Mirroring this trend, the percentage of people in prison incarcerated for sex offenses also spiked, almost entirely due to the incarceration of non-rape offenders, and despite a lack of significant change in sex crime rates. So since the 1980s, state and federal governments have engaged in a massive project of legislative control, surveillance, and punishment of sexual criminals. This trend has been driven largely by a series of highly public cases against children, beginning in the late 1980s, which heightened public fear of sexual predators and fueled concern about the risk of previously convicted sex offenders reoffending. So the first of national legislation was the Jacob Wetterling Crimes Against Children and Sexually Violent Offenders Act in 1994, which created the first sexual offender registration legislation and required that people convicted of sex offenses provide identifying information and locations to law enforcement. That was expanded in 1996 by Megan's Law, which required that all states also conduct community notification and create internet sites where their information was posted about people convicted of sexual offenses. The most expansive set of legislation came in 2006 with the Adam Walsh Act, which established national standards for registration and notification and established SORNA, or the Sex Offender Registration and Notification Act, which kind of creates the governing standards of today's sex offender management regime. It expanded the amount of information available to the public, established a 3-tier designation system of registrable offenses, and expanded the criteria for which people had to comply. So as of 2017, approximately 861,000 people registered in the United States for a wide range of offenses that range from statutory assault to indecent exposure to assault to rape to many others. Despite what we think of when we think about sex offenses, many of these are first-time nonviolent offenses. Overall, about 1 in 470 adults are required to register, 98% of whom are male. Rates are twice as high for Black men as white men, and roughly 1 out of every 119 Black men in the United States are required to register. That's about 1% of all Black men. So, what do these laws do? This is a system that was built in response to public fears, intended, questionably, to keep people safe from violent crimes by strangers against children, and to keep known sex offenders from reoffending. However, the unfortunate reality for the efficacy of these laws is that sex offenders and sex crimes do not match this profile. Instead, most sex crimes are committed against adults and by someone known to the victims. There is also no single sex offender type, despite popular and political portrayals. And sex offenders have extremely low rates of sexual recidivism. So, unsurprisingly, given this mismatch of evidence, empirical findings demonstrate overwhelmingly that these policies do not reduce reoffending or reincarceration rates, or really have any impact on public safety. However, what they do have is an immense set of collateral consequences that include homelessness, reduced employment and educational opportunities, stigma and isolation, increased symptoms of poor mental health for people required to register. So then we get to mandatory sex offender treatment. Mandatory sex offender treatment programs are designed to keep sex offenders from reoffending and to correct underlying pathologies or problematic thought patterns that led to the offense and develop coping strategies. They operate in all states and are typically a precondition for parole or a condition of supervision. They typically involve individual and group therapy and are often based on cognitive behavioral therapy models. They typically require that individuals disclose and admit to the underlying offense and/or submit to polygraph tests. In the case that people are unwilling to do so, they are often put into a deniers group or unsuccessfully discharged from treatment, which can be a violation of conditions of parole or probation. There's only some mixed evidence of effectiveness of these models, and they're all specifically tailored to specific types of offenders and for specific types of therapy. However, these models are applied indiscriminately, typically for everyone coming out of jail or prison with a sex offense. So we conducted a study with the 2 facilities licensed by the state in the city where the study took place to provide community-based mandatory sex offender therapists. There's 2 sites, and participants were assigned by probation and parole officers to one of these 2 sites based on officer preference, insurance, and/or treatment capacity. So this study was a qualitative, semi-structured interviews with the therapists who are providing MSOT, the specialized probation and parole officers who supervise people on the registry and often coordinate treatment with these providers, and people themselves who are in MSOT. Our goal was to explore the experience of all 3 parties with the ethical and practical challenges of providing and receiving treatment, beliefs about the purpose and value of treatment, navigating and reconciling conflicting professional commitments, and the interplay and tension of goals, velocity, safety, and agency values. So I'm going to focus just on a couple of our key findings from the interviews mostly with probation officers and therapists, which I think highlight the challenges and tensions inherent to working in and around mandatory and coercive treatment settings. They also revealed the way in which poor and unclear definitions of the mission and responsibilities of various actors and services pose challenges and conflicts. So the first notable finding was that there was an unresolved question of who is being served by these therapists and the treatment settings. While generally we think of treatment as for the client, this is clearly a more complicated question in the context of mandatory and coercive treatment settings. In many ways, it was the probation offices who send clients to treatment and oversee their compliance who are actually the client being served. A therapist described to us, "That was a big part of treatment, engaging probation and parole, which complicates things a bit. Informed consent and confidentiality look different when they would in normal treatment settings, because technically the probation and parole offices were the client as far as the confidentiality stuff goes. If there were certain concerns, we had to report them to probation and parole, so it wasn't like private as therapy would generally be elsewhere." In other ways, the community writ large could be considered the true client, in the sense of being the intended recipient of value from treatment settings. A PO explained to us, "Although our ultimate call with probation is to help those individuals succeed and to move forward with their lives after committing offenses, we can never forget about the victims in the community and the potential that an individual could pose for the future." So in this way, probation officers were making treatment assessments and decisions about compliance based on concerns not for the client themselves, but for the client as the community. These understandings of who treatment is for guided the way services were provided and the ways in which harms to the client could be devalued or overlooked. A second finding was the sense that the stakes are really high in these settings, which can influence the terms of treatment decision-making. This especially posed challenges for therapists who are struggling to reduce or avoid harm for their clients, while navigating through systems in which they're required to cooperate with probation and punishment systems. A therapist told us, "I feel like I personally kind of walked on eggshells, being worried about, I don't want to tell the PO anything unless I really have to because they're going to get sent to prison. They don't get a slap on the wrist. They don't get scolded. They don't get told you have 5 more chances. They go to prison. Another told us, it's just really heartbreaking. This guy came in 7 minutes late, and he had been late like 4 or 5 times before. I was like, I can't send this guy to jail just for a couple minutes. But then a supervisor of mine said that if you don't set a boundary, he's just going to take advantage of it. And he kind of made me, and he was sent back to prison. Largely because operating within these systems is complicated and traumatic for therapists, as well as poorly paid and difficult, the therapists providing services in these settings were often those with the least training qualification to support this complicated, high-need population in this difficult setting. All 3 stakeholder groups identified this issue. These people who ran this program, the only background they had was they read in a book, a client told us, and I couldn't accept that. You can't know what we feel and what we've experienced in our heads and our hearts and not know what's going on. A therapist admitted, as a new practitioner, I was just reading right off the worksheets. And another said, truly, I don't feel like I was a great therapist. I feel like I was just, most of the time, going through the motions because I didn't know what to do with them. Interestingly, probation officers were the most likely to express confidence in the expertise of treatment providers, explaining that by putting confidence in the therapist's expertise, they could feel more comfortable trusting their recommendations and staying in their lane as enforcement officials. However, they noted that it seemed that treatment centers would often assign a student intern or someone who was fairly new, and that rates of turnover made it very hard for a client to receive consistent services. Indeed, their confidence in treatment providers was often tested by the reality of their partnerships and proved to be much more of an aspirational confidence than an actual one. That leads me into one of our more interesting findings. Going into the study, in the beginning of our interviews with therapists, we had the sense that therapists were butting up against the public safety orientations and coercive conditions imposed by the criminal legal system, and these external conditions limited their ability to provide high-quality care to clients, and that they took on the singular role of shielding clients, in some cases from criminal legal sanctions, by limiting what they shared with probation or applying some level of discretion in their work. And indeed, therapists spoke with us about navigating the constant threat of someone returning to incarceration and strategies they use to limit someone's exposure. One therapist described that he would share less information with certain POs because I just knew they either didn't like a client or they had an attitude about therapy. There were some POs that would want them to be in the program for years and years and years. However, one of our most surprising findings once we began also talking to probation officers was they also felt like they were protecting and shielding clients from treatment providers. While they're more inclined to want to trust the expertise and training of therapists, they often experienced almost a reversal in roles, where it seemed like there was the therapists who were more punitive and obstructionist than the probation officers. Every PO we spoke with described navigating tense relationships with therapists and situations where it felt like they were the ones advocating on behalf of the client to the therapist. One PO described, I like to have the opportunity to intervene with my offender before they're going to face a discharge or an issue. So I try to stay closely involved with the therapist, just by email, like, how's this person doing every once in a while, and sometimes getting involved on behalf of them. If I think they have a lot going on, I'm making sure the therapist is aware, like, hey, can we work with this guy a little bit, if there's issues with attendance or illness or drug issues that are going on. That might be creating issues, with treatment. The POs didn't enjoy this advocacy role they felt forced into playing, and they resented that it felt like blurring their own professional boundaries and role. One PO told us, I also think we shouldn't be advocating, but described that when I see a situation where I'm like, this isn't right, I can't help myself, because they're not violating, and I take treatment recommendations seriously, but I've had people told they couldn't go to a place of worship, people being told they couldn't go to the gym, people being told that they couldn't do other things. I didn't understand that. It wasn't against their rules or our rules. She went on to describe, I've had people coming in telling me that the therapist told them, oh, well, you're going to get this charge and you're going to jail. And I'm like, they don't decide if you go to jail. It's not even just like they're stepping on my toes thing. It's like, why are you threatening people? I don't even like to threaten my own people if I can avoid it. So I don't think it creates a healthy relationship. Every PO we spoke with discussed similar circumstances where therapists seemed to want to create additional restrictions for their clients or keep them in treatment for much longer than they believed was necessary or helpful. A PO supervisor told us, well, there's like when we feel that the person has gone as far as they can in treatment, but treatment's telling us they want to keep them in, we're like, come on now. He's been there for like 3 years. We think you gave him significant gain, but we want to move on. Another PO, I had a guy who was there for like 3 or 4 years, and he was like, I can't talk about what I did anymore. I've talked about it for 3 or 4 years every single day. It was like almost messing with him. When do we say, okay, he went through the cycle and did all his modules? So to quickly wrap it up, what we see here is that everyone sees themselves as the well-intentioned actors, but feel limited by the constraints of laws, systems, and the other stakeholders they work with. Everyone saw themselves as operating in a protectorate role against the other, often acting outside of their traditional boundaries or their professional scope to do so. Additionally, another important finding, mostly outside of today's scope, but has implications for today, is that everyone also noted the profound challenges presented by SORNA and the many collateral consequences of being on the registry. However, not a single person, including all of the clients on the registry we spoke to, supported ending those policies. This was despite the fact that not a single person could identify an instant or circumstances in which these laws had prevented harm or prevented reoffending. Everyone expressed issues and challenges. People recognized the ineffectiveness of these policies in their anecdotal experience, but no one would endorse ending them. Clients told us that SORNA had been devastating for them and had not been helpful for them personally, but it was really important to keep people safe from some other. Similarly, therapists and POs could not describe circumstances when these laws had protected the community from their clients, but reiterated their broad and general importance. Briefly, this speaks to a commitment to the manufactured idea of the unique dangerousness of sex offenders, which stymies imaginative thinking about treatment, punishment, and policy or alternatives. This is a significant challenge for future research, and what makes these policies resilient to reform despite evidence of ineffectiveness. So as we think about today in these discussions, the two final questions for us as we continue research and for all of us here who are practitioners in different ways. And that's, how do we push back against the strong belief in the unique dangerousness of this population and the belief that the mechanisms in place are inevitable? And then what tools and strategies can we use to unify understandings of the goals of treatment across these different parties? Can treatment ever be therapeutic in this setting? And what should the goals look like and for whom? And especially given the profound gap of services we see everywhere. Thank you.
Thank you so much for having me here today. I just wanted to say this being here puts me in mind of when I was in law school many years ago. And we used to do symposia at my law school. And I swear, I did more than one that probably had an attendee list about as large as one of these green tables. And it's just thrilling to see so many of you here today for this meeting, and it's a real triumph for the organizers. So thank you so much for having us. I do have prepared remarks. I'll try to get through them as fast as I can because I always learn more from the discussion that follows the prepared remarks. And I was here this morning for this morning's discussion, and I was very pleased that it seemed to not pleased, but I was compelled that it focused on the intersection of mental health and mental health disability with the criminal legal system. And although my remarks today are not may not seem directly focused on that, it is definitely a huge component of the work that we do at my office, the Bazelon Center for Mental Health Law. This may seem like a shameless plug, but I'm happy to talk about it. Last year, our office worked with the Legal Defense Fund to do a paper that reviewed the really tragic history in our country of when people make calls to 911 because they're concerned about the behavior of, in particular, Black people with mental health disabilities. And we called for communities to develop the capacity, aided by federal and state resources, to provide timely, meaningful, alternative responses to a law enforcement response when there is a call for help involving someone with a mental health issue. We really need to work to make sure that our public safety systems can respond appropriately when people need help. And in most cases, and I would say far more than we see today, including in Baltimore, as everywhere else, too often we have a police response to a mental health issue when we should have a mental health response. So I just want to put that out there before I launch in. Today, I wanted to focus on my organization's long-standing, decades-long work against forced treatment. And it is a benefit and perhaps a detriment to be the third person on a panel. You'll certainly hear themes from me that you've already heard, probably more compellingly than I may do them. But anyway, I work for the Bazelon Center for Mental Health Law based in Washington, D.C. The Bazelon Center is celebrating its 50th anniversary this year. We advocate at the national, state, and local levels for the rights of people with mental disabilities, including people with mental health conditions and people with intellectual or developmental disabilities. We engage in legal and policy advocacy to advance the rights of people with disabilities to live independently, with freedom to make informed choices about where they live, what they do during the day, and what medical care they receive, and to live in their own homes and communities with the supports that they need and want to enjoy all the opportunities for daily living and community participation that everybody else has. The Bazelon Center has for decades opposed forced treatment. And when I say forced treatment, what do I mean? Forced treatment may be the product of legal action, such as forced hospitalization through the execution of an emergency petition, or forced inpatient or outpatient treatment through an involuntary commitment order. Forced treatment may also involve action that is inconsistent with providing informed consent to treatment, such as the use of restraints or seclusion in treatment settings. The Bazelon Center believes that forced treatment is only appropriate in the rare circumstance where there is a serious and immediate safety threat to other people. Even when a court may have ordered hospitalization or a course of treatment, any use of force to effectuate treatment is only appropriate when the legal standard, generally an imminent risk of serious harm, is met. Application of this standard should take into account whether efforts to de-escalate and stabilize a situation have been made and are successful such that the standard, the legal standard, is not met. In general, circumstances that give rise to the use of force in treatment are not spontaneous and do not occur in isolation. Usually there were multiple opportunities for earlier interventions that could have prevented the need for force. For this reason, and to counteract coercion that is too often routine in our behavioral health service systems, it is important to regard the use of forced treatment as a system failure and an indication that the system needs to be reformed. The Bazelon Center considers itself a civil and human rights organization. We seek to advance the rights of people with disabilities in all aspects of life, including in the systems that provide them services. We also work to eradicate racial and ethnic disparities in the systems that provide services to people with disabilities, including schools, healthcare, the criminal legal system, the child welfare system, and other human service systems. Forced treatment is a serious rights violation involving the loss of liberty and autonomy inherent in being able to make one's own choices about the care that one receives. Not only is forced treatment a rights violation, it is counterproductive. Fear of being deprived autonomy discourages people from seeking care. Coercion undermines therapeutic relationships, including in situations where providers may be required to testify as to whether an individual is compliant with the prescribed course of treatment, and long-term recovery. Reliance on forced treatment may confirm false stereotypes about people with mental disabilities being inherently dangerous, even though available evidence shows that people with mental health conditions are far more likely to be the victims of violence than the perpetrators of it. And the experience of being forced to be treated, historically an experience that involves some degree of physical restraint, is traumatizing and humiliating, often exacerbating a person's mental health condition. For far too many people, and too often Black and brown people, the use of force to effectuate treatment may result in physical injury or even death. We're told that people with mental disabilities will not consent to treatment, including because they lack insight into their condition. In too many cases, this assumption is based on stereotypes about people with serious mental health conditions and reflects a failure to listen to them and to encourage them in identifying what services they think would be of value in their lives and would meet their needs. We know that it doesn't have to be that way. Communities across the country are employing proven methods to meet the wants and needs of individuals with serious mental health conditions who otherwise too often experience homelessness or housing instability, and as a result, cycle between the streets, the emergency room, and the jail. Research indicates that effective engagement of people with mental health conditions in public spaces, including by people with lived experience with homelessness working as peer specialists, helps individuals see the value and agree to participate in supportive services. Safe, stable, and affordable housing provided with voluntary supports has been shown to help these individuals stabilize and avoid hospitalization and incarceration. And voluntary community-based services such as assertive community treatment or ACT, supported employment, crisis services, and peer support services delivered not in the hospital, but in the person's own home and community have been proven successful. I will say more about those services shortly, in part because these are the services we seek in all of the advocacy that we do. All too often, I'll say now, public safety and behavioral health service systems turn to force and coercion because they lack such services in adequate quantity and intensity. At the Bazelon Center, we advocate for self-determination in treatment decisions and work for systems that avoid force and coercion. Such systems listen carefully to people with mental disabilities, support them in communicating their preferences and interests, and offer the types of services and supports that they prefer. Such systems do not simply respond to crises, but develop plans in partnership with the individuals they serve to avert crises. When treatment plans are imposed, it is not surprising that the individual may not comply with the plan. When that happens, the person should not be punished with a longer period of supervision before gaining freedom. Shared responsibility for the person's voluntary participation in services promotes buy-in and better treatment outcomes. In the long run, the best way to secure treatment compliance, we believe, is to respect the individual's informed choice. Despite the efforts of people with disabilities and their advocates, over the 5 decades of the Bazelon Center's existence, we have seen states enact laws that have entrenched regimes of forced treatment. Following seminal U.S. Supreme Court decisions from the 1970s, including O'Connor versus Donaldson from 1975 and Addington versus Texas from 1978, states have amended their involuntary commitment laws to comport with the court's holding in O'Connor that there is no constitutional basis for confining people with mental health disabilities involuntarily if they are, quote, dangerous to no one and can live safely in freedom. Under Addington, evidence to the contrary must be clear and convincing. States adopted these standards, but over time, as states closed their institutions but did not adequately fund their community-based behavioral health service systems, such that many people with mental disabilities experienced homelessness or housing instability without access to services that would help them be successful in the community. Over time, states broadened the scope of their involuntary commitment laws. In addition to requiring that individuals pose a risk of harm, a danger, to themselves or others in order to commit them, many states now provide that an individual with a grave disability or inability to provide for basic needs for food, clothing, and shelter may also be forcibly treated. Also, commitment may not mean inpatient hospitalization anymore. In 2016, 47 of the 50 states were found to have some form of involuntary outpatient commitment, a status in which individuals are ordered to comply with a treatment plan for participation in community-based treatment and services. Such plans usually require the individual to take medication and sometimes direct where the person can live and what their daily activities must include. These trends toward ever greater use of forced treatment predate the COVID-19 pandemic, which is commonly believed to have prompted a mental health crisis in the United States and around the world, with more youth and adults reporting psychological distress from conditions including depression, severe anxiety, post-traumatic stress disorder, PTSD, and co-occurring substance use conditions. Along with increased reports of chronic mental health conditions, changes in our work culture meant that many of our city business districts have emptied out of workers, making those residents experiencing homelessness or housing instability, along with behavior that appears to be symptomatic of behavioral health issues, more visible than before the pandemic. These conditions have prompted new efforts to expand forced treatment, even in jurisdictions we may consider liberal or progressive. For example, last year, the California legislature enacted and California Governor Gavin Newsom signed into law the Community Assistance, Recovery, and Empowerment, or CARE Act, which establishes a new court system in which people with schizophrenia or other psychotic disorders will be required to comply with a court-ordered treatment plan or face conservatorship and lose the freedom to make choices about all or many aspects of their lives. As people with disabilities and their advocates testified to lawmakers, Black and brown Californians are more likely to be diagnosed with these mental health conditions and are more likely to be homeless, and so are more likely to experience the deprivations of liberty that accompany a CARE court petition. 2, the CARE Act does not actually increase funding for the housing and services individuals under a CARE court-ordered treatment plan will need to be successful, or that could be offered voluntarily before the individual faces forced treatment. Another example. Late last year, New York City Mayor Eric Adams announced a new policy directive under which police officers, emergency medical technicians, and other responders are to transport homeless individuals to psychiatric hospitals involuntarily when it appears that they cannot, quote, meet their basic needs. Mayor Adams provided as examples individuals who are mumbling, shadowboxing, or merely standing on the street for too long. Mayor Adams' new policy ignores the fact that decades-old research from New York's own Bellevue Hospital showed no statistically significant differences in rehospitalization rates, arrests, homelessness, or other outcomes between participants randomized to receive involuntary outpatient commitment and those randomized to receive intensive community-based services without outpatient commitment. This was a finding confirmed more recently in a study from the United Kingdom about 10 years ago. Like the CARE Act, New York's new policy also ignores that Black and brown people with mental health conditions are overrepresented in the city's homeless population and so are more likely to be involuntarily hospitalized under the mayor's plan, and under the plan may be subjected to traumatizing and dangerous interactions with law enforcement responders that have historically resulted in serious harm, including death. Closer to home, here in Maryland, the state has proposed amendments to its emergency petition regulation last year that would expand the circumstances under which a person would be deemed dangerous and subjected to involuntary hospital admission. Among other things, the revised regulation would permit an individual to be detained if their behavior places others in reasonable fear of physical harm, a broader standard than the current regulation, which we fear could result in commitment orders issued based on the subjective perspective of a bystander or a judge. This is particularly problematic for Black and brown people in Maryland who are already disproportionately involuntarily committed and who often may be perceived as more threatening by others due to the color of their skin, mode of communication, or other factors. The Bazelon Center stands with people with disabilities and their advocates in California, New York, and Maryland and opposes these efforts to expand forced treatment. All of these proposals invite stakeholders in these jurisdictions to make subjective determinations about whether a person with disability poses a danger to themselves or others now or in the future or is otherwise gravely disabled. These stakeholders include the bystanders and first responders, including the police, whose complaints set involuntary commitments in motion, and the judges who signed orders allowing them to take place. What should be done instead? The Bazelon Center has long supported the following alternatives to forced treatment, all voluntary. Number one, housing, providing safe, affordable, permanent housing, along with the supports that people with mental disabilities need to attain and maintain tenancy, has been shown to lead to housing stability, improve mental health symptoms, reduce hospitalization and law enforcement involvement, and increase satisfaction with one's quality of life. Stable housing is a prerequisite for people with mental health disabilities to be able to focus on and engage in recovery, and a powerful motivator for people to engage in treatment. Having a roof over your head is a near foundational precondition for the journey to recovery in the community. Scattered site housing ensures that people with mental health conditions will have access to all the amenities and opportunities in the neighborhood that everyone else can access. Housing with supports is also significantly less expensive than institutional care. Many states have rental subsidy programs that can be used to help provide housing to people with mental disabilities, including until the individual is able to secure a federal rental subsidy. States may also obtain Medicaid funding for pre-tenancy and post-tenancy services and supports, and also one-time expenses like security deposits, moving expenses, and paying for furniture and establishing utilities. Number two, voluntary intensive community-based services. Every state and locality should have the capacity to provide an array of services that have been shown to prevent hospitalization and incarceration and help people avoid crises of the sort that prompt commitment proceedings. In particular, assertive community treatment, or ACT, which is probably familiar to many of you here, has been called a hospital without walls. It is a multidisciplinary team approach to providing an individualized package of services and supports that have been proven effective in meeting the day-to-day needs of people with serious mental health conditions. Team members provide counseling, peer supports, case management, psychiatric services, supported employment or supported education, and substance use services, among others. The team should be or is on call 24 hours a day to address the individual's needs. ACT teams are, or should be, the first responders to their clients in times of crisis. For those not receiving ACT, mobile crisis teams can come to wherever the person is in the community to help de-escalate mental health crises. Mobile crisis teams should be available 24 hours a day and should be able to respond to calls for help as timely as do law enforcement responders. They should be able to link an individual with ongoing voluntary services, such as ACT services, and have access to community-based crisis apartments where individuals can stay for a short period of time as an alternative to hospitalization. Supported employment is a package of services and supports aimed at helping people with serious mental disabilities get and keep a job in the mainstream workforce. Supports are not time-limited and are focused on the individual's vocational goals and preferences. People with lived experience working as peer support workers can and should be involved with, if not leading, all of these services. Peer workers can serve on ACT teams, on mobile crisis teams, and as street outreach workers. They can provide employment supports and operate community crisis apartments. Peer workers help their clients stay connected to treatment providers, build confidence, maintain or develop social relationships, and participate in community activities. Of all service providers, peer workers are often the closest to the individual being served and advocate for them with other provider staff. As I think many of you know, peer work is fast becoming a primary component of the behavioral health service delivery system, and individuals receiving peer support services report increased social connectedness and the ability to address stressors and crises. These are all evidence-based practices that can be prescribed in a dosage that makes sense for the individual and is commensurate with the level of risk that the individual might relapse. They are services which, when delivered with fidelity, are delivered with the empathy, alliance, and positive regard which comprise a robust therapeutic relationship that will make recovery more likely to be successful without resort to coerced or forced treatment. States may seek federal funding through Medicaid for all of these critical community-based mental health services, as well as others like intensive case management, respite services, outpatient substance use services, and are increasingly doing so through innovative methods like home and community-based service waivers, state plan amendments, and demonstration projects. One more item I wanted to mention, and this is one we have supported in conjunction with others, Psychiatric Advance Directives, or PADS. Psychiatric Advance Directives provide a legal means for individuals to refuse or consent to future mental health treatment during periods when there may be a question about their capacity to provide consent. PADS may include advance instructions for mental health treatment decisions or proxy decision makers, or both. More than just an instrument for crisis planning, PADS are now considered part of a remedy for individuals with mental disabilities experiencing a sense of disempowerment and alienation from treatment. And in this respect, PADS are consistent with the current movement toward self-directed care, which in this circumstance may diminish actual as well as perceived coercion, improve service engagement and effectiveness, and thus promote long-term recovery. Statutes permitting the use of some form of psychiatric advance directive exist in about half the states. We think the rest of the states should consider enacting or strengthening these statutes so that they're clearly treated by behavioral health and public safety systems as legally relevant indications of a person's informed choice regarding treatment. By investing in these services and methods, states can restore the balance in their behavioral health and public safety systems so that they more appropriately value individual autonomy and liberty, and more likely help people with mental disabilities avoid the interactions with others that typically engender forced treatment. And I'm going to stop right there and look forward to the conversation that is happening now. Thanks.
So we'll now open up the floor for any questions.
If you don't mind coming over here just because of the speaker.
Hi.
Oh, we have one in the back?
Here? Yeah. I really appreciated the presentations and learned a lot, and wanted to follow up with a question I actually had even for the first panel. I think it probably fits all day, and it's a question and a sub-question. There's the matter of mandatory treatment, but I'm constantly faced with the question of mandatory treatment that doesn't even fit, the one-size-fits-all. And ironically, coming out of primarily doing child welfare work as a social worker and teaching, and being very frustrated with there's maltreatment or risk of maltreatment, so you must go to parenting class when it's not a knowledge issue, it's a housing issue, it's a poverty issue, it's many other things that need support, not knowledge about toilet training. But as I've moved more into working with those involved in the justice system, I'm finding, serving on a reentry court, that individuals are mandated into one-size-fits-all treatment. I thought I'd gotten away from that. We don't have necessarily the evidence-based treatment services available. We have what we have a contract with, as it turns out, and not an assessment before you go there. So the question is, how can we look at, or is anyone looking at more of an assessment of what the needs are now when, say, just pick reentry population, that how can there be more of an assessment, not just we have a contract for X treatments. Therefore, these are the treatments you're mandated to. And the sub-question is, increasingly, at treatment, psychosocial treatment or of various kinds, there's mandatory drug and alcohol testing, which is kind of a disincentive to go to your therapy sessions if you're going to have to test, because most folks that I know are probably going to test most days positive to alcohol or marijuana, legal for many, but not for people on so then you get violated in the federal system. You go back for the whole time because you haven't been going to your sessions that don't fit and don't fit your psychosocial needs, and or you have a bad tox screen. So when we're talking about all of that, what ideas, who's doing, Philadelphia, in DC, what do you know in Maryland and Catonsville and around about how to fit the mandated services? I understand some mandated services and coming out, say, on probation or parole. But how do you get a fit of what those services are? If you can fix that, that would be really great today. So that's it.
I can start. So I think there's a couple layered issues, right? We've discussed what the complications and issues are with mandating in general, and then the problem of mandating to services that don't make sense or are provided by poorly trained therapists or people without the resources to do something. And the solution to that is a couple-fold. It's A, don't mandate, but it's also that you do some sort of assessment, that you assess what people's needs are and apply treatment appropriately. But the problem is and places are doing some level of assessment, but more often the underlying issue is that the services that they assess people need don't really exist. And that's, you can assess all you want, but if there isn't a robust social service infrastructure that's available and accessible to people, you don't get anywhere. And so the reason people refer to the same practices, they have a contract, but also they'll take people. And if you don't have other things built up, you can kind of create the front end structures and not get anywhere on the back end. And I think that's something that and certainly in Philadelphia, see over and over again, is that people innovate really creatively in some spheres, but they don't build out the underlying foundation in a way that can actually effectuate those assessments. So that's certainly a problem that I see. And certainly, obviously, the drug screens are a big issue, and it's when clinical goals come into conflict with legal system goals, and we know that those things don't match up in really any way. But I think the challenge is more the resources underneath. And then also realizing that the legal stakeholders are not the experts in this, and convincing them of that there's like a kind of withdrawing from the God role of the judge or the court officials to give off that expertise to someone who maybe does have the training to make appropriate assessments.
So I was just thinking the frustrating thing for me with the question you raised is we have known for a long time what to do. We have the knowledge, we have the science, we know what to do that will help people, but we're not willing to pay for it. So part of it is about what's politically expedient, what's politically popular, and how do I get reelected. And when putting money into the kinds of community programs that we need for people isn't one of those things. And ever since I started in social work practice 1,000 years ago, we knew what to do. They weren't putting the money in to have it available.
Sorry, I know we want to get to you, but I just thought I would add from the perspective of the kind of legal advocacy that we do, just to tag on and say I agree. I was on the phone yesterday with someone who was asking us about our position on screenings for depression. And one of the things I said to the person was, the problem is that people can be screened and screened and screened, but there's no capacity to provide follow-up to the screening. And so it just feels like that's going to be one flag that shows up on a person's record that maybe they popped up as like positive for having depression, and that could be stigmatizing down the road. But then there's in many contexts, no real ability to provide the kinds of follow-up services that the person may want, or that the person, may think they need after some period of engagement. And it's just in all the contexts where we work, the capacity to actually provide the services, the capacity to, and I think we're moving further and further into the world of ensuring that the systems have capacity to provide people with lived experience the ability to participate in providing services. But that's what we're looking for. And I agree that there's nothing that indicates that a judge ordering intensive services is going to be more successful than the person engaging and agreeing to, because they see the value in being in service and receiving services. And so it's really the capacity issue that we have to address. And I agree that as a country, as communities across the country, we haven't done it. We've deinstitutionalized, but we've not done the other part of it, which was to build up the community service capacity.
Thank you. I just want to speak again to what I see is missing here is not engaging the current socio-political environment that does not believe in science, that is cutting funds to pay for the concept of what is being provided. And unless we engage that, this is just kind of daydreaming. I'm old enough to have participated in the community mental health movement. And all of these things were known then, but the current environment is saying that this is some kind of daydream that those of us who are interested in assertive mental health, etc., they're not accepting it. I mean, Medicaid for certain populations are going to go away May 11th. So my question is, where do we bring these things so that we confront, and I mean confront, the absence of the capacity to deal with these things that are being suggested?
I'll start, but I encourage my fellow panelists and everyone else to try to respond. And I suppose I think about this. It may indicate a privilege to think that advocacy can make a difference, because that's what I do. And if I didn't think that we could somehow improve the world in which we live, I probably wouldn't do my job. I'd do something else. I agree with you, and this comes up in a number of contexts in which we do daily work. We're working on issues around Medicaid and the availability of Medicaid to provide community-based services versus institutional care every day. We constantly are out there. You would probably do it better than I would, but we're out there talking about how harmful institutional care is, how harmful forced care is, and how outcomes are much better and rights are protected when people are served in their communities with the services they want and need. I think that we may need more and more effective witnesses. who can provide personal narrative. I suspect that this year we may have to do what advocates did in 2017, which was to do civil disobedience at the Congress when some deal is made around Medicaid this year, or is attempted to be made. You know, people in wheelchairs were arrested in 2017, the last time they tried to cut Medicaid. And I think that it is a helpful thing when people testify in that way, and I think that may be what we need to do again this year. That's probably not a very satisfying answer.
I think that's a really hard question. I guess I think back to when I graduated from college. My very first job was in a social rehabilitation program connected with a community residential rehabilitation program designed to help people reintegrate in the community at the tail end of the deinstitutionalization movement. And it was a really great program. And then Ronald Reagan was elected. And those programs were gone. And then we were into trans institutionalization, which we were still talking about today. And I guess where I have seen big change is when people in power champion the issues, like when Governor Hughes became Senator Hughes, and he's a recovering alcoholic, and he pushed and pushed and pushed the Congress to do better and do more, and actually sort of institutionalize the research institutes in DC around substance use. And we had a proliferation of knowledge and treatment around substance use, you know. And Kennedy, with the mental health issues, advocated for the Mental Health Parity Act. And it seems like somehow we get the big change when somebody in power really champions the cause, is when I've really seen the big change happen. But of course, we can all advocate, and we can all try to make change where we can. But like you were saying, to have an organized big push. But we keep pushing. It's not popular money-wise, and I can remember that program I was talking to you about. The neighborhood fought it, and we were like 22 years old, standing in a room of hundreds of community people screaming at us about bringing these people in their neighborhoods, and ultimately we found a place to do the program. But it was really a challenge, and it ended up. It really was a great program. But how do you get it? It's not popular to say we're going to spend thousands and thousands of dollars in these community programs, and somehow I guess with public education we could try to help make it more popular and get people in power to champion the change.
I don't know that I have anything particularly profound because it's a huge problem, but I guess I would say that the optimistic side of me as a researcher and a social worker and advocate is that the more learning and talking we do about all of this, there are going to be pendulum swings back and forth, and we see this. We see all the patternings of things get rolled out and then turn into these unintended consequences and rolled back, and policy failures, iterations of it again and again. But we can hope that there's at least some foundational building blocks of learning and norms that get embedded during these moments of swinging one direction that mean when they swing back, they swing less far because certain things have become so normed or deemed unacceptable that they can't swing back as far. And then that's maybe how progress gets made, is that the pendulum just swings a little bit more and a little bit more. But I don't have a great answer either. So.
Thank you for this rich discussion. I have a question, and actually this is one of the papers that I'm currently conceptualizing right now in terms of this coerced or forced institutionalization. I'm wondering, why is it treated so differently when it comes to mental health, but when it comes to medical care, it's almost accepted? In my journey, I was a hospice social worker for a period of time, and it gave me great perspective of working with children by working with people who are preparing to die. And I had patients that I worked with that had suffered from, let's say, esophageal cancer, and they had an advanced directive, and they said, I refuse to take blood treatment because of my religious beliefs. And the medical community accepted that. They said, okay, this person is choosing to refuse treatment. But when it comes to mental health, it seems like we have a different set of standards where we are forcing people who have schizophrenia or who have bipolar to say, well, I have to take this medication, or the government in California, in New York, and other states are saying that you are mandated or we're going to coerce you in order to comply into treatment, and you don't have that dignity as an individual to determine your own fate. You don't have that agency to say that I choose not to do this. I have a young lady who was taking some medication for schizophrenia, and the medication gave her tardive dyskinesia and the trembling. But she was a part of a community that did embroidering, and she liked to sew. And she said, I refuse to take my medication because I want to be a part of this community, which I find extremely therapeutic and supportive. But they could be forced because they're not complying with their conditions of release, or they're not complying with some community standards. So why is there that disparity? And I'm going to pose that to everybody.
First off, I should just say I appreciate the analogy you make. I do not identify myself as a person with a mental disability, but I am a person who has had cancer, so I do appreciate the analogy. I will also say that I think that there is... I have been part of many conversations with people from people who might describe themselves as survivors, people who describe themselves as advocates, who wonder what it will take or what investment it will take to educate the public about how people who have mental health, who have been diagnosed with mental health conditions, can actually make their own decisions, can express their own preferences, are not intrinsically dangerous. Even if they may appear to, quote unquote, lack insight, they're actually making the same kinds of cost-benefit analyses that we all make. There is a perception that people with mental disabilities can do none of those things and are dangerous, and it's because their behavior does not conform to societal expectations and it disturbs others. Whether or not they actually feel threatened, they feel disturbed. And folks in the communities in which I've traveled through my work at the Bazelon Center have looked at other efforts to educate the public in a way that would lessen stigma. And we think about people with HIV/AIDS and how, I'm old enough to remember back in the 80s and 90s when that condition was so stigmatized, and people in the LGBTQ community who have, for whom our societal attitudes have changed so much, so often, not always. I just think we just have to keep, we just may disagree, but I just feel we have to keep working at it, and testifying, in every, those of us who work in the mental health communities have to be able to come out in the same way that others have had to come out about other things, and that may be the only way in which we eventually get to. And I don't know if I'm not pretending that I will see it, but that may be the only way in which we can get to societal policies that are not based on stigma and misunderstanding.
Let's give our panelists a round of applause. Alrighty, so we will now take a brief 15-minute break before our final panel at the law school. Thank you.